Hello and welcome to Passing the Bar, a video lecture series brought to you by Delaware Law School. My name is Professor Brett Bendistis, and today's lecture is going to cover a lot of things under the guise of constitutional law. Now, a lot of the things that we like to do here on this video lecture series is talk mostly about essay construction. You know, one of the things that I found is that a lot of the MBE topics and the memorization of stuff, a lot of that's repetition, right? A lot of that's like, the more you do it, the better it comes along. You keep working toward your goals and you'll get there, right? Essay construction is a little bit different because I think the struggles with essay construction are there's a lot of cooks. You know, depending on who you work for, you might get a lot of different people who are kind of giving you recommendations. The other thing is that a lot of writing can be subjective. You know, one of the things I've always thought of is that teaching people how to write, particularly legally, is a lot like teaching people how to dance. There's not a perfect way to do it, but there's definitely like a right way and a wrong way, right? So the idea of what we're going to talk about today is a little bit of the broad strokes of like how to construct essays, how to think about topic sentences. That's going to be the big one of thinking about like your first sentence. The point of this first sentence also is that it's not a matter that we're going to radically change your writing, right? I mean, I don't think that you're good, you would get a 1 and then, a good topic sentence will automatically give you 6 if it's a scale of 6 to 1, right? But I think the bigger point is thinking a little bit more about the idea of like how do you, again, raise your floor on questions you're not good at? How do you raise your ceiling on things that you are good at? The bar exam is so much about points. I had a conversation with somebody yesterday, and there was this point of, how do you appropriately manage your expectations? And I think that there is a misstatement in the idea of thinking about, well, set your expectations low. You don't have to be perfect. And I think that's like a lot of things about you don't need to strive for perfection, but perfection is a fine goal. As long as you are able to manage the fact that you don't need to have 100 to pass the bar, but that you should strive to get the best possible points that you possibly can. To me, the idea of what we're working on today is just sort of streamlining some concepts and making sure that we can improve upon the little details to, again, make sure that maybe essays that you are not as strong at, you can get like 1 extra point. And the essays that you know that you're good at, you know that you nail. One of the big things I think of sometimes is like, if you've had me before and you've watched these lectures, you know that I love reality television. And in particular, one of my favorite tropes in reality television is like the 20 experts in a TV show, and every week we eliminate one person week by week. I think I said this even in the last video. And so one of the things that I always find, right, is that whenever there's a person who's like, this is my expertise. I'm a wonderful French cook. I'm great at making this type of clothing. Top Chef and Project Runway, respectively. That's the week they go home because people get comfortable assuming that their knowledge and their comfort in a certain topic will carry them through. That's not the way that it works. I think of this as a matter of if you know a topic and you're great at it, maybe it's constitutional law, maybe it's something else. I want to give you a small pointer of thinking about the idea of something that you can do that'll take a few extra minutes and it'll really make sure that, again, your essays are getting the most amount of points possible. Cool. All right, now, we're going to talk about constitutional law today. I want to bring up a few big points, a few narrow points, a few practical points. The big thing that I also want to talk about is this here, iTunes, the Citizen's Guide to the Supreme Court, is a podcast that I have done for the last 11 years on the United States Supreme Court. Now, my daughter, who's 2 years old, she's adorable, but she's a maniac, has taken up a lot of my free time. This is not going to be on the bar exam, but the more kids you have, you drop hobbies one by one. And the podcast is something that I haven't done as much, but I imagine over the next couple weeks with a few more Supreme Court cases coming in, this is the end of the Supreme Court's term. If you're watching this as it drops specifically, you're going to see a few more Supreme Court cases. I bring this up only. One of the suggestions I'm going to make is the best way to get good at constitutional law is to learn about constitutional law. But I'm going to start here, and I think this is a really important point when it comes to this topic, but also other topics, is that often constitutional law at law school is taught very theoretically, right, analytically, talking about individual justices. And that's a fun way to do it, talking about the history that leads up to certain topics. Right? Like you can't learn about Roe versus Wade until you learn about substantive due process and you learn about all the, I can't think of the word that they use to talk about the surrounding areas of privacy. But the point is that like you don't need to write a historical dissertation on constitutional law to pass the bar. You need to worry about the tests. Tests are the most important thing. And so one of the things that I think distinguishes constitutional law in law school and constitutional law in the bar exam is practicality, thinking about what are the type of things that a bar examiner is going to want to know. And so while yes, you certainly could spend a great deal of time explaining the historical origins of the 14th Amendment, but I like to think of constitutional law as being able to spot really specific issues, being able to narrow in your answer really particularly to that issue, and to make sure the bar examiner knows, very specifically, you know the answer they're looking for. Again, that's different, I think, when it comes to other areas of constitutional law, where you want to, I might even go as far as to say pontificate. Not the time for that. You don't have a lot of time. So one of the things we're going to talk about is we're going to deconstruct an old MEE constitutional law question that I think represents two different types of constitutional law issues. We're going to talk about a few things that come up kind of commonly when we think about constitutional law. Now, the first thing I want to know about constitutional law is that constitutional law serves two different purposes. That usually you have two different things that constitutional law is dealing with, which are the two different parts of the Constitution. The first part of the Constitution is obviously to organize the government. Right? It organizes the three branches of the federal government, and it also defines the relationship between the state and the federal government. I will note that in my research of looking at old MEE questions that are available online, this is, I find, more of a focus than you might imagine. Right? I often tend to think that we think of constitutional law as like First Amendment cases and abortion cases, but this scope and jurisdiction and relationship between the branches of government, to me, feel like a more pressing constitutional issue, I think, in the general sense of the way the world is. You know, again, as somebody who studies the Constitution and the Supreme Court pretty intently, someone who does CLEs, that's me, by the way, I'm that person. It's a common reoccurring issue that's constantly coming up. You know, I have a slide on this later, but I'll ruin it now. You know, when we think about like the big cases that may have affected your practical life, you know, things like the COVID mandatory vaccines, right? Biden's case. We talk a little bit about the loan forgiveness, again, Biden again. Those aren't about whether or not the Supreme Court likes vaccines or whether they want loans forgiven, directly at least, but it's more about the idea of the relationship between the administrative and executive branch and the legislative branch. Are they stepping on each other's toes? We think about like Trump's immunity case. That's a separation of powers case. And so the point that I will note is that this is a little less exciting, right? It's a little bit, again, less theoretical, but I do tend to think that like you would be remiss to not think about constitutional law in the context of jurisdictional requirements and the relationship between how the government works. We'll talk about that in a second. The other thing, again, is a little bit more sexy, for lack of a better word, which is protecting citizens from government overreaching, which is the other part of the Constitution that we know a little bit more about. The idea that like the state or the federal government doesn't pass laws that infringe upon your civil rights, things like equal protection, which we're going to talk about, due process, First Amendment, things like that. We also have criminal procedures also kind of weaved into there. The big thing to talk about, and this is one of the things that I want to talk about with future lecture episodes, is the idea of like practically what are we dealing with? And practically what we're dealing with is like someone versus the government, right? So when we think about things, you want to be phrasing questions about the idea of like, what is the procedure of the case? You know, to show the bar examiner practically that you understand how constitutional law works. Meaning that in most instances, that if you're challenging the imposition of federal jurisdiction, well, then you would be thinking about who's bringing the challenge to the federal jurisdiction, right? Who's challenging the law? You know, we think a little bit about, like, you may have heard about the TikTok case, right? Federal government bans TikTok, people get mad about it, everyone loses their mind, goes to the Supreme Court. That's a case where it is multiple parties against the federal government, all right? The point being there is that what you're often going to be thinking about is the idea of who's at issue and who's going to win. Make sure your conclusions are really strong, and thinking about the idea that if you're talking about equal protection, well, then you're talking about a person who is challenging government authority. All right. Now we're going to talk about that in a quick second, but I want to do one more thing, and I want to talk about a little bit of a writing style point that comes up a lot, and it's sort of like a potato-potato thing. Iraq versus Korea. Okay. There's all this talk of like, well, do we teach Korea? Do we teach Iraq? The idea to me is very comparable, and the idea of like my personal approach normally, and this is normally how I wrote, is I like my first sentence to qualify the issue in a way that represented the conclusion. Now in place of that is the idea of stating the conclusion that represents the issue. So it mostly is a matter of like the phrasing of the first language. And what I'm going to do now is I'm going to write more in Kriak form for this first sentence. The main thing I want to note is I think your first sentence of your essay should be something that you look at right before you're done if you have the time. Meaning that I want to make sure that any bar examiner who reads your essay knows from the first sentence that you know what you're talking about. Right? That seems like a good idea. Because you have to think that a bar examiner is probably grading hundreds of essays and wants to know right off the bat whether or not you know what you're doing. And so this is a main point that I'm trying to instill, is the idea of thinking about your first sentence with a little bit more attention than maybe you're thinking about, right? What we're going to do here is we're going to talk about like what's the question, but then we're going to come back after we've analyzed the entirety of the problem and we're going to rewrite the first sentence to again give the bar examiner an idea of that you know exactly what the ending is before it starts, right? Every good story, every good movie, right? You'd hope, knows the ending, right? Goes back and makes sure the ending is leading in there. That's the idea, is I want your first sentence to foreshadow your conclusion. I often found, right, I've taken 3 bars. I took Pennsylvania, New Jersey, and Delaware, and I wrote them all by hand, okay? So I sort of had to do this in real time as I'm writing bar exam questions. Now, in practice, right, on my computer, what I've often found is that with the timing considerations, that if I plan things well and I understand what I'm doing, I've got at least 30 seconds to go back and look at that question one more time, right? That's first sentence one more time. With the point being, let me go back and make sure, again, that sentence tells the bar examiner first sentence, I know exactly what I'm talking about. I know the entirety of your issue, all right? Now with Delaware's fast, right? And what I mean by that is that was my big observation I took, because I took a sample Delaware bar exam before the bar, is that it just went quicker than I anticipated. It was fast. And so in that instance, I felt like there was more an impetus to know that sentence before it started. But also I tend to think that if you budget enough time and you go back and fix things, I think it's doable to make sure it's there. The key thing being, we're putting a little bit more attention to make sure the first sentence, right, represents the legal issue and the determinative facts so that the bar examiner knows, right, your first sentence gives a really strong first impression to make sure it works. Now what I have here is a constitutional law question. This is from February 2015. It's an MEE question. It also is going to be available on your Canvas page. So if you want to pause the video now and read it, you can also, I guess, kind of read this while I'm talking. The main thing I want to talk about here is that there's a lot of points here and there's a lot of, I'm going to say, fertile grounds for analysis that's baked into this question, where if you don't read it overly carefully, you may miss things that I think are really important that can strengthen your issue statement from the very beginning. First thing I want to note is, let's go to the questions first. Does the Act violate the Equal Protection Clause of the 14th Amendment? Will Congress have authority under Section 5 of the 14th Amendment to enact a statute barring states from establishing maximum age for firefighters? Okay, I like this question because it represents 2 different points of the Constitution. The first is government overreaching. The second is the organization of government jurisdiction. Now, a few things I want to point out to you. I think the Equal Protection Clause is generally a little bit easier from a conceptual point of view. What you have here with your fact pattern is you've got State A who decides that they're going to start an age limitation or an age limit or mandatory retirement for firefighters. By the way, this is generally, I believe, an actual case, or maybe it was for police officers. But this is like the most common hypothetical when you deal with rational basis, rational basis scrutiny, I think, for things that seem unfair. I know that's sort of a mouthful, but the idea is like, this to me is the most common version of something of, yeah, that we don't love it, but it illustrates the idea that rational basis usually wins, right? So the idea of rational basis is, yeah, it's super easy to jump into it and be like, well, it's rational basis, we know the government's going to win. But that to me isn't something that I think a bar examiner wants to see. A bar examiner wants to see, I think, 2 main questions with a few different subparts. First, they want to be able to know that you're able to establish what the standard of review is and why it's that standard of review. On one hand, you can disqualify the other two, strict scrutiny and intermediate scrutiny, and qualify the fact that if it isn't that, it's a rational basis. You can also add in the fact that age discrimination is commonly rational basis. So that's another thing that's sort of important to include. The other thing that I think is also worth noting is that you want to make sure you go through the applicable test really specifically. Now, one of the things about rational basis review is that it always, all equal protection considers the government interest, and it considers the connection of the law to the interest. My friend has this really good analogy that I do my podcast with, that I like to steal, right? He was an old Delaware Law School student, so he doesn't mind that I take it and use it in my classes. But it's kind of like a bullseye, right? Like rational basis is the idea of, if you've ever played darts, the idea that rational basis is like you just have to make sure the dart sticks in the dartboard. Now, if you're coordinated, which I am not, by the way, throwing a dart into a dartboard probably isn't that difficult. But it does take a modicum of skill, right? It's the same thing here when it comes to rational basis. Most laws should pass rational basis because it's deferential to the government. But if it's truly incompetent, i.e. truly uncoordinated, right, you're not going to pass. And so the idea here is that it's not enough to just say, yeah, it passes rational basis because the government does it. You have to articulate the government interest, which I'll note is baked into this fact pattern. And there's also, I think, a really important part here where it's talking about physiologists, it's talking about physical conditioning, it's talking about safety and efficiency. That's there for a reason, meaning that this to me is the type of question where it really wants you to articulate the standard and show that you know what it means. It doesn't need an extensive history, but it's really this idea of nailing all the points of the test, meaning that establishing the standard is knowing the other extraneous circumstances, but actually going through the test is a very particular analysis, applying all of these facts very particularly to the answer. So in general, when we think about what we're talking about a rational basis standard, we're talking about a interest of efficiency and safety, and we're talking about a pretty substantive record that goes over the idea of that they've proven that this is a good idea. I also want to talk about the fact that you've got a few not red herrings, but just things that you really want to be thinking about that you might want to argue. First, thinking about the idea that you have the firefighter who's like, hey, I'm great, excellent physical condition, and I want to stay here. I think that's something you want to address as a counter-argument, right? The other point I want to note is that they are saying that it's for health, safety, and efficiency meetings, but they're also bringing up that it's there to save money, right? That's there for a reason. So one of the things I think when you think about going over these fact patterns is you may not have a lot of time to go over things. And so budget into the idea that you are thoughtfully reading through it and you're not rushing through it too fast. I am a speed reader. I talk too fast. I think too fast. This is something that I had to practice very considerably, where I would read the rubric not for the answer, but making sure that I was addressing these really particular facts and mining every single sentence for every single point to it. The other question, we talk about jurisdiction, right? Lobbying the enactment of a federal statute barring states from setting mandatory age limitations for firefighters. Two different points here. I think we're going to get to these in a second. I tend to think that this is less of a factual analysis, and it's more of a legal analysis, which again we'll get to later. The point being is that both of these questions, though, are really important. And so you want to think about budgeting your time to making sure you're really hitting what I think is both of the questions. The first point is the rational basis review. The second one is about federal jurisdiction, but very particularly the narrow view of what federal jurisdiction means for this question. All right, coming back to the PowerPoint here really quickly. I talked about a lot of this stuff, but I want to just kind of reinforce some main ideas that we want to be thinking about. First, the idea is that the standard will be rational basis, which is the default standard that applies. I think that one of the things that I think people ask is like, well, how much extraneous material should I get into? And I've always heard that law school exams are like building a straw house, right? Just sharing everything you know. I don't know if that's totally applicable here, but I also tend to think that, like, I think it's worth noting the fact that if I had a question, I would probably really hit rational basis, really kind of go over it, go through that test. I would probably add a sentence or two that was like, it's not strict scrutiny because it doesn't deal with race. It's not intermediate scrutiny because it doesn't deal with gender. I know that's like reductionist, but you sort of get my point, right? That, you know, say why the other things don't apply, but make sure you're qualifying the idea that it's rational basis and it's stating why. That why is so important. You know, in a lot of ways, one of the biggest senses of feedback that I've been giving is the idea of making sure that your application section is analytical, right? This is true because, this is true because, this is true because. And so the essential idea is that if you're talking about, again, standards of review and why, that would be a big point. The other thing I would note is that I would distinguish my paragraphs here as the first being what is the standard, the second being the test, right? So we're going to talk a little bit about the government interest, safety, and efficiency. We're going to address counter arguments on cost effectiveness. We're going to talk about the counter arguments about the individual firefighter. And then we're going to talk about how it's rationally related. We're going to discuss the hearings. We're going to use all the facts relevant. Now, the main point we're going to note coming out of this is like, well, now how do we go back and think about ultimately what's a good topic sentence for this? How do we state the conclusion for our CREAC in a way that best gives the bar examiner a way to know that we know what we're talking about? So like the first one, right? State A's law is constitutional under the Equal Protection Doctrine. I don't love it. I think it restates the question, but it provides no analysis, meaning that like, I think that's the right answer. That's a great conclusion. But I think that like most people will say that, right? So I think at the end of the day, one of the things that you want to do is think about like, how do we make this person who's reading my exams life easier, right? State A's law is constitutional on a rational basis review. It's better, right? But it still doesn't foreshadow the idea of what the answer is. And so again, I'm not saying this is perfect. Teaching people how to dance, right? You might do this differently. But if I was writing this question and I was like, how can I go back and make sure I have a first sentence that's chock full of information? I'm going to write the firefighter will not be successful in challenging State A's law under equal protection rational basis review because the government can prove a legitimate interest of safety and efficiency and that the law is rationally related to that interest based on the government's evidence in the hearings. Right? And I don't mind if I do, right? The point being is I go over the procedure, I go over that it's rational basis, I talk a little bit about the legitimate interest of safety, I also talk about the government's evidence in the hearings. Now again, maybe there's more to it than that. Maybe you want to add a little bit more extra detail, address these counter arguments. But I feel like a person who reads that sentence is going to be like, this person's checked all the boxes that I need on the rubric, and it makes their life easier. That's the key. One of the things that I think I've harked on in my last video, and that's worth seeing if you haven't seen it, is the idea that like the start of every paragraph should begin with a strength. And I think of that from constitutional law. If you read Supreme Court cases, you can follow them pretty strongly just by reading the first sentence of every paragraph. I don't do this professionally, but with the podcast that I do, I read a lot of Supreme Court cases. I've read most of the Supreme Court cases over the last 10 years. I don't read them all word for a podcast I do for free, but in areas where I just want to kind of get through like a concurrence or a dissent, there are times where I will just read the first sentence because the first sentence is mostly like how it dictates the answer, right? It gives you the conclusion, then it explains why. Conclusion and then why. And so I like to write like that. I like to make sure that anyone who can read my writing can read the first sentence of every paragraph, have a really strong idea of where I'm going with it. This is something where, again, you do have a pretty long amount of time before the bar exam. And so if you haven't done this yet, start incorporating it more, but also give yourself time to edit if you need to go back, right? Let's talk about the next question here, because the next question to me is actually a little bit more deep and actually requires a little bit more of an analysis of how it works. We talk about jurisdiction, right? I found jurisdictions pretty common, right? Talking about preemption, talking about the relationship, federalism between federal and state government. If I had to guess, right? I think the relationship of like administrative law, it's just so prevalent in how constitutional law is really being analyzed right now, right? The ability of the president to use administrative agencies to bypass the legislative system is a very like the last four presidents problem, right? And it's not just a Trump problem. It was an Obama problem. It is a Biden problem, where if you can't get your job done through the legislative branch, you kind of figure out a way to like use administrative law to kind of like shoehorn your policies in. It's the same thing you see with like the Department of Education. A lot of the things that Trump's doing, where again, it's trying to bypass the thing. The thing being the Constitution, right? So the point is that like this would be something. I'm not saying prioritize it over other things, but it's the kind of thing I might think about some fine details on. Because what I think is true here is that like when I first read this question, I was like, it's a jurisdictional question. What's federal jurisdiction? Well, federal jurisdiction is, it's governed by the Constitution. It's Article 1, Section 8. It's interstate commerce. It's national sovereignty. This question is a little bit narrower than that. and I want to talk a little bit about what I got from a outline and how to think about it if you're not totally sure what it means, especially with an area that you know is important, right? So like this is the paragraph that I think is important, right? Article 14th Amendment, Section 5, Enabling Clause permits Congress to pass legislation to enforce the equal protection and due process rights guaranteed by the amendment. Great. That seems good, right? Under the separation of powers, the job of defining rights falls to the Supreme Court. Yikes. And enforcing such rights, there must be a congruence and proportionality between the injury to be prevented or remedied and the means adopted to achieve that end. What a fantastic sentence. That sounds so cool, and I don't understand any of it, right? The point being is that there's a lot of fun buzzwords there, right? And that seems really important, especially because there was a bar exam question on it. But one of the things I want to note that if you're reading this, and let's say you had an outline, and maybe the outline or maybe the lecture didn't give you a full bit of detail on it, something really easy that you can do that I would just consider in a few different areas if you're lost. So a few things that we can do, right? The first thing I will note is that if you still have a Lexis account, which I believe that you still do, you can look up the case. You know, one of the things in this outline is that, like, you know, again, proportionality and congruence is a wonderful word if you understand it. But one of the key things to note is that, like, there is an easy way to, like, look up cases and to check things out and to make sure they work. I'm going to do a lecture video a little bit later on some of the more difficult practical areas like family law and property. And one of the things that I think is important is that, like, you know, family law makes sense if you practice family law, right? If you've never practiced it, it's a little bit difficult, right? Property law, I do think can be dense, but like mortgage, mortgage priority, things like that, can make more sense if you read more cases. I'm living proof. I've argued many lien priority cases. The point being is that, like, if you don't know and you need some practicality, this isn't the worst place to go because it can give you some material that I think can show you what things look like from the perspective that I think a bar examiner wants to see. The other thing is that, again, if you see City of Bourne versus Flores, you know, I'm not saying go to Wikipedia, but OIA is a pretty good website to get into things. What's another one? You know, for newer cases that come up, SCOTUS blog is a wonderful place. It's a great place to build a podcast. But the idea is that, like, taking a little bit of time to understand what the words mean, I think is going to pay big dividends, especially with things that you might see are commonly tested or areas where you may be running into a couple problems. So summarizing these concepts really quickly, I want to talk about the way that I would structure this answer ultimately, right? Is the first thing I would note is that I would address the idea that Congress does have authority under the Constitution to pass laws that begin with the 14th Amendment. So again, step by step, right? One of the things I think about the law to note is that sometimes, like, the first step is good and then the second step is, like, bad. That happens all the time, right? But I think you want to talk about both of those steps because it shows that you understand, again, the procedure of how things work. The thing about being proportionate and congruent, right, is that you have to make sure that, like, Congress can't use the 14th Amendment to ban something that's constitutional. That's, like, in so many words. And so the idea is that, like, yes, they can ban things federally that violate the Equal Protection Clause, but this doesn't violate the Equal Protection Clause. That age discrimination statutes pass rational basis review. So the Congress can't step in and say, all right, well, we're going to ban something because it doesn't violate rational basis review because we want to protect firefighters. But the point there is that, like, it would fail. So the answer is, like, no, right? The answer is that law would not work because it's outside their jurisdiction because, again, they don't have the constitutional power under the case to make sure it's there. Now I want to note something. That's a hard question. Like, that was a hard question for me, and I'm not studying as the same way that you're studying. I will note, however, that, like, I have practiced law for a really long time, and I've done a Supreme Court podcast. I bring this up because, like, as a lawyer, successful lawyer, articulate lawyer, and me, right? I don't memorize every aspect of the law. I can see the issue, and I know where the problem is. And so, to me, it's a matter of being able to see that question and to slowly take your time and look at it and say, there's a little bit more depth there than just saying, well, federal jurisdiction's just jurisdictional basis. You know, the other thing I will note is that, like, what helped me out is just reading the table of contents. And I know that this is sort of a matter of, like, if you know the law but you're struggling with issue spotting, that helped me out. It's like I would just read the table of contents over and over again just to get a good idea of, like, where are things I need to know and where are they related to one another. And so if we go back to our issue statement, right, and we're going to go to, like, this idea of, like, what's a good first sentence. Congress does not have jurisdiction to pass an act banning age discrimination. Great, it's a fine conclusion that restates the question, but it doesn't give a good idea of what's the problem. Although Congress has the authority to pass laws under the 14th Amendment, a law banning age discrimination would not be proportionate and congruent under Flores because age discrimination is constitutional under the Equal Protection Clause. That's pretty great, even if I do say so myself. The idea being is that I went backwards, right? And I changed that sentence to make sure that the first one wasn't what I was leading with, because the first one doesn't show the bar examiner that I know the entirety of the question. Now I'll note something before I go. There are going to be times you're going to run out of time, right? There's also going to be times where I think you may not know the answer to the question. I still tend to think in all of these instances, you want to think about, again, having a narrow point of law for your rule, for your application, and then representing that same level of a narrow conclusion in your first sentence. Again, this is not something that's going to pass the bar for you specifically, but the key thing is that I just want to get you closer every single step of the way. And so if there's small things that kind of the extra 2% that's giving you that extra advantage, that's what I'd like to do. Now, my email address is over there. My podcast is over there. There are two things that you can use over the next couple weeks, even though I'm sure you are very tired of listening to people talk about the law. I get it, right? But the point being is that if you want to hear about how there's an equal protection case that just came out the other day. A friend of mine and I, we went to Delaware Law School. We're both very happy and successful. The idea being is that hearing about how people talk about the law, whether it's my podcast or another, might give you a little bit of hand with it. The other thing with emails, if you have any questions and you're watching these videos and you would like me to review an essay, I'm always more than happy to do it. And I will take some time and I'll make sure I give you a hand, because I generally find a lot of people know the law, and if they don't pass the bar, sometimes it's about writing, clarity, structure, and things like that. So again, if I can point anything out to you, I'm more than happy to do so. Thank you very much for listening to these videos, and I'll be back probably within the next week or two. We're going to keep talking about these and really kind of focusing on the idea again, raising your floor, raising your ceiling. Good luck with studying. You're almost halfway there. I know it's probably crazy, but you're doing a great job. And again, everyone here is rooting for you. So good luck, and I'll see you soon.